Well, I think we've got 5 o'clock. Daphne, what do you think? Should we make a start?
Yeah, let's do it. Okay, welcome everyone to Family Law Now After Hours. Thank you so much for joining us today, whether you're on Zoom or watching on YouTube. Today's topic is protecting your business during divorce. The purpose of this series is to discuss general information on separation, divorce, and family law matters, and any advice provided here should not be construed as legal advice. Please utilize the Q&A feature, whichever platform you're on, to submit your questions and comments for the panelists. And if you have any questions regarding your specific matter, please feel free to call our office or a lawyer in your area if we are not, to book a consultation to receive tailored legal advice. And stay tuned until the end, as we will be sharing how you can schedule a complimentary consultation with one of our lawyers. Okay, so I'm going to introduce the lovely speakers that we have here today. So first up is Jason Kwiatkowski. He is a founding partner and the president at Valuation Support Partners Limited. A professional services firm specializing in providing the business and legal communities with business valuation, litigation support, and exit planning advisory services. Jason is an independent financial neutral and has completed numerous business valuation and expert reports, including income assessments for various purposes. He has testified before the Ontario Superior Court of Justice as an expert witness in business valuation and damages quantification. So thanks so much, Jason, for joining us today. We also have Melanie Russell with us today. She is the founder of Kalex Valuations, Inc., which she founded in 1996. Throughout her professional career, she's been involved in many assignments for a variety of public and private companies of various sizes and across many industries, obtaining her training at two of the largest international accounting firms in the industry. Melanie placed second in Canada on the CICBV membership examination. She has been active in teaching business valuations and related topics since 1987 at various universities and professional organizations, and runs the premier preparatory course for CBV students in Canada taking their national membership qualification examination. In 2023, she was elected and designated as a CPA Ontario Fellow. So thank you, Melanie, for joining us today.
Thank you.
And last but certainly not least, we have Russell Alexander, the host of Family Law Now After Hours. He is the founder and senior partner at Russell Alexander Collaborative Family Lawyers with over 25 years of experience. He uses his knowledge and expertise to serve his clients in all aspects of family law. He's written 4 books and is a fully trained collaborative practice lawyer. And he speaks at conferences on collaborative practice, technology, and the law. So thank you, Russell, for inviting me on to begin this discussion. I'll pass it over to you, and I hope you guys have a wonderful show.
Great. Thank you.
I think you're muted, Russ. There we
Have
go.
have a great evening. Thank you for the introduction and kind words. So let's make a start. Like Daphne said, we're just having a discussion here. We're not giving legal advice. Very high level. Melanie and Jason have some great information on their websites, and there's other live events we've done if you want to drill down a little bit deeper into some of the topics we're talking about tonight. But the theme or the theory with the After Hours program is more of a discussion like we would have with our neighbor or our family friend. We're not dispensing legal services or professional services tonight. We're just having a general discussion. So understanding the impact of divorce on your business interests and assets. Let's just do a high level overview, and then we're going to drill down a little bit more. You want to start us off tonight, Jason?
Yeah, absolutely. I've got a few thoughts to get it started. I mean, I think we all know divorce can be complicated, it can be time consuming, it can be costly, it can be emotionally draining, and add a business to the picture, and it just amplifies that. I mean, thinking about a divorce, if you're running a business, going through a divorce can really shift the owner's focus and attention away from the business. And the business owner has customers, clients, employees, deadlines, quality issues, like all of these things to deal with. And if the focus is shifted away from the business, hopefully someone's taking care of that. Divorce, as we probably know, also requires the valuation of the assets in businesses for property division. And valuing a business requires disclosure of sometimes sensitive and confidential information, right? Financial statements, tax returns, business plans, forecasts, and so on. I mean, many business owners don't want that in the public record.
Mm-hmm.
And then if a business is jointly owned between spouses, I've seen situations where, there's lack of trust and one spouse takes funds out of the business for various reasons, and then you've got to deal with tracing that and looking into that. I mean, it can be very costly. It can be very stressful, which can, honestly lead to health problems, mental and physical. It could be a big impact on the business.
Yeah. Great tips. Melanie?
Yeah, all good points, Jason. So I'll just add a couple things. The one thing I've sort of learned over the years is that people may not be realistic that when you go through a separation and divorce, you split the households, that means the lifestyles are going to change. You are not going to have the same lifestyle as if you were still together. So you've got to kind of accept that very early on. So that usually means that the higher income earner or the spouse that has more assets or net assets will have to transfer some of that or somehow, not necessarily in the same form, but they'll have to transfer something to the other spouse. So you'll end up with not as many assets and lower income for at least some period of time during the separation. And the opposite is true for the spouse that doesn't have, is lower earning and has less assets. And of course, it also depends whether you're talking common law or marriage, because there could be a few interesting twists there that you have to watch for. And also, I think, very important to realize that any equalization of assets doesn't mean that you have to give away those assets. So if you own a business and you hear this thing, you have to share the value with your spouse. That doesn't mean you have to give the ex-spouse shares of the business, but you have to give them something equivalent in value. So that can be a whole exercise in itself, trying to figure out after figure out the value, how do you then find the equivalent of 50% of that to share it? And I guess one last comment is that there isn't just, it's not just necessarily the value of the shares of the business. There may be other things you have to consider, like money you owe the company or the company owes you, or disposition costs to get the value of that company, the shares into your hands.
Wow. How are we going to break this down? The way we've done programs on the golden goose. I consider a lot of businesses are a golden goose. And what we want to try to do is keep that business operating and providing for the family, even if they're separated. A lot of my clients have adult children working in the business as well. So their careers and their livelihoods are dependent on the business. And like Jason said, this is it could be a fragile entity, right? If you're distracted, the owner's distracted or is not focused on the business, it can fail. So you gotta be very careful with these businesses to ensure that my goal for most families is continued success. Let's keep this golden goose going so we can continue to have it generate wealth for the family. But great introduction. So understanding overview of the laws and regulations governing business division in Ontario. 4 big points I wanted to touch upon. And Melanie had a great point about common law. So we're going to talk about some statutes, but just because you're not married doesn't mean you may not be able to make a claim to a business. So that claim could be a trust claim. It could be a resulting trust, a constructive trust, a joint family venture. So there is discretion, and the court will step in if you meet certain requirements to ensure that you get your fair share. But the main statute in Ontario is the Family Law Act that talks about what Jason and Melanie start talking about. It's basically a regime to help people share their assets that they acquired during the course of their marriage. That sharing process is what the lawyers and the professionals call an equalization payment. And there's a schedule and there's net family property statements, a whole bunch of ways to go about doing it. It's just a fancy way of saying you're going to share your property that you acquired during the course of the marriage. Some things you're going to want to keep in mind: valuation date, which is going to be your date of separation, is important. Excluded property can be pulled out of this sharing process. So if you brought the business into the relationship or into the marriage, you may be able to exclude some or all of that asset, depending on whether it's increased or decreased in value. So you want to be mindful of that. We talked a little bit about the judges getting involved. We have the legislation. If there's no agreement, a judge may come in and make an order, maybe for the sale of the business, for the division of assets. The other, in addition to dividing property, judges can make support orders, spousal support orders, and that often affects the business. People may hide their income in their business, so we may need to attribute income to that person if they're dealing with cash, or not disclosing all their income, or maybe just making the business cash rich to try to lower their income so they don't pay support. So judges will look at that, and lawyers are very good at seeing these patterns, and Jason and Melanie do income assessments on business owners to understand what their income is. The other important thing Jason touched upon is tax, right? We're all subject to the Income Tax Act, and the business is going to have taxes, and they're going to be treated differently. There could be dividend income, capital gains taxes. You want to do some planning regarding disposition costs. So if you sell that business or that asset, there may be a tax component to it. So all these need to be factored into when you go to share your asset or your business. Most importantly, you want to get legal advice or the advice of professionals like Jason and Melanie. These are complicated assets, complicated tax treatment, lots of unknown knowns. So if you don't do this regularly, there could be things that you overlook, or landmines that you're not considering, that could blow up in your face or destroy the business, or result in a different value than you think the business should be worth. So lots to think about, but in a very general sense, those are some of the 4 big things you want to be considering. The sharing regime set out in the Family Law Act. Judges will likely get involved if there's no agreement. Possible support claims that will flow from this business asset, and tax implications. We can spend an hour just talking about this one subject, but we want to give you a flavor of what you're looking at when we go to divide your business up after a divorce, or if you're separating from a common law spouse. So the next thing we're going to talk about is asset evaluation methods for valuing. We're going to talk about the process of valuing your business, but other assets as well. And oftentimes, I practice law, but I understand when it's outside my scope, I'll bring somebody in like Jason or Melanie to talk about how we're going to go value these assets and what methods or recommendations they would use. So you want to start us off on this one, Melanie? Is it you're
Sure.
up first?
Sure. So I'll say from a big picture, that was a good introduction in terms of looking at values of more than just businesses, right? Because people have lots of other assets.
Yeah.
Sometimes it's very straightforward. It's a bank account. You can just find the bank statement, get the account balance at the relevant valuation date, marriage date or separation date or cohab date, whatever the dates are here, or current date. So it may be easy. Not so easy with some other assets like businesses. Or stock options, things like that can get a little more complicated. But from a big picture perspective, the idea of valuing an asset is looking at what someone would pay for it. That's typically what we as valuators start with. Like, we're numbers people. So thank you for all coming here to listen to talk about numbers. It's very exciting for Jason and I, but not always exciting for everybody else. But that's ultimately what we're looking at, is what would someone pay. Now, that doesn't mean a court or judge or someone might not change the interpretation, but we're putting this little pretend box around it that pretending we want to sell the asset, and pretending that there are people out there that know that we're interested in selling and what they might offer to pay us. So it's supposed to be this, what if we wanted to sell, what would we get for it? And that applies to, an inventory of wine. You've got wonderful wine cabinet downstairs. Same thing. What would someone pay for all this wonderful wine? What would someone pay for the couch? Now, so there's some realistic ways to look at things. Some can be a little more hypothetical. So often when we get into valuing businesses, we may not have much to go on other than, what are the business operations? How have they done? Or you may have situations where someone has actually sold some of the shares recently, or there may be a formula in a shareholders agreement, or there may be other kind of metrics we can grab onto. So as valuators, we try to grab onto as many things as possible. And it can be expensive, it can be time consuming depending on the assets. And one of the things to just be from a common sense point of view is that hopefully with some assets you might be able to find common ground and maybe not spend a lot of time arguing about it. A great example, and I'm sure Russ can speak to this, is household goods.
Mhm.
How much do you want to spend on someone valuing the couch, the dining room table, the chandeliers, the bed, the this, the that? Is that really going to make sense? But if the ex-spouses can agree on how to split something and not go through that, then it might be as creative as you can be, and especially when everyone's on decent terms and are agreeable, then it may be a lot more cost effective.
Yeah, I used to have a judge tell me and my clients all the time, I don't do pots and pans. Don't come to me with pots and pans. I'm not dividing it up. And
Animals? What about animals though?
that's hard. In BC, you can get an access order now, but it's still property in Ontario. But yeah, do you have two people in the courtroom to see who spot rents to? Is that how you do it? I don't know.
I guess, yeah.
But the judge always say, go in the hall and figure it out. I'm not giving you an order on pots and pans. But Jason, you want to add to Melanie's comments here?
Yeah, I think just a quick takeaway when you're talking about valuing assets that are not businesses is really the standard answer is it depends. Like it depends on the asset we're talking about. Like some will be easier than others to value, like a bank account or an investment portfolio, because like Melanie said, there's a statement. But you will need supporting documentation. You'll need to verify whatever value you're attaching to this asset. So like other assets like pensions and real estate and artwork, and Melanie mentioned stock options, you may need to get an appraiser involved, right?
Yeah. And that couch you bought from the brick 2 years ago that has a stain on it, it's no longer worth $2,000. It's worth whatever somebody's going to give you on the side of the street at a garage sale. That's the number we're going to go with. But it's important to keep that in mind. Okay, so let's move on to precautionary measures, strategies for protecting your business interests before marriage and during divorce. I don't know how I got this one, but there's 4 points I want to talk about. Obviously, before marriage, get a prenup agreement or a domestic contract signed. Disclose your business, make sure the contract sets out what you're going to do with that business. Should you separate, you're going to want both people to get independent legal advice, full disclosure. If you fail those 2 basic steps, there's a good chance that agreement may be set aside. So that's usually, we see that often, especially with second marriages where people don't want to divide their assets again. Oftentimes there'll be a marriage agreement drafted so they can protect their assets, but you don't have to wait to get married twice. You can do it at the front end. The business structure is another way you can protect these assets. So you want lots of different ways you can structure your business. You may be a sole proprietor. You might have a van full of tools, and you're a self-made business person, whatever the trade is. You want to look at maybe incorporation, partnership agreements if there's other business owners. A big tool we see quite often are family trusts to protect assets. It can get complicated when you go to family court and there's a trust involved. It's extra work, but that's one way that you could potentially protect your assets. Look at the compensation structure, look at the agreements. You can organize your business potentially to protect it if you're going to go through a divorce. If you're already in a divorce, that's a different situation. First step is get legal advice and representation to help you from start to finish. Engage one of the professionals like we have on here tonight to give you an idea of what some of these taxes implications are going to be. What are some ways we can generate options to share this business, but keep it running potentially? We've done legacy agreements where my client wanted out, but her husband was a very effective businessman. So he continued to operate the business. She kept some of her equity in there and shared in the profits going forward. If you do a legacy agreement like that, you want to be mindful that everybody's will and power of attorneys are consistent with that. If they enter into a new relationship, you're going to want to consider a domestic contract to ensure that the previous arrangement continues. Lots to unpack there. Business continuity plan. I'd strongly encourage you to come to a negotiated settlement. Everybody on the panel tonight has collaborative practice training. If you don't know about collaborative practice, do a Google search, contact one of us. We focus on goals and interests. So we're sort of giving you a rights-based analysis tonight, what the legislation says. When we do it collaboratively, we can be flexible. We can come up with agreements that judges cannot in terms of businesses and how we're going to structure any settlement. So encourage you to look at mediation, arbitration to avoid the court system. If you have a spouse who's not going to agree on anything, and we see this all the time, it may be necessary to get a court order. And so you may need to commence a court proceeding. So those are some of the things you want to look at. Also, we talked briefly, there could be support obligations flowing from your business. You want to protect yourself from those obligations. Maybe you get a domestic contract, or if you're negotiating a settlement and you're already in the process of divorcing, you want to consider if you can obtain a spousal support release. You may have to pay a bit of a premium for it, but that will end off provide you with some closure and avoid, future claims against your business for ongoing support obligations, depending on the nature of your relationship. A lot goes into spousal support, length of your relationship, ages, whether somebody suffers a disability, the ability to be self-sufficient, the roles that people played during the marriage. Children could also create what we call a compensatory claim for support. There's lots to think about there. We've got live programs that just talk about spousal support. Look for us online. But it all connects to this business asset. And if you're trying to protect it, you're going to want to think about potential support claims that can flow from it as well. So that's sort of a broad overview. Jason, do you want to jump on the bandwagon here? Do you want to add anything to protecting the business?
I think that was pretty good.
Okay, thanks. Melanie, anything you want to add?
Yeah, I agree. Lots of ways. And I guess just to wrap that up, making sure you consult with professionals, because most people are not going to have all the options and creative solutions at their fingertips. So you really need the right professionals.
In every after hours program we always talk about financial disclosure and how important this is. And what we're going to talk about tonight, what is financial disclosure? What are the professionals talking about when they throw that word out there? But the importance of maintaining accurate financial records for your business and how that helps when it comes to separating or dividing your business. So I think, Jason, you're going to get the first kick at the can here.
Yeah, I've got a few points on this topic. I think this is a very, very important topic. This is a critical topic. I think most business owners appreciate and understand that accurate financial information is necessary for their own internal decision making, for proper tax filing, and even more so when going through a divorce. I mean, why? Because when you're going through a divorce, and we talked about this earlier with valuing the property and the net family property statement and the division of property or equalization of property, part of that process of preparing that statement is the disclosure of financial information necessary to value the business. And that's things like financial statements, tax returns, general ledgers, contracts, agreements, bank statements. And I just can't stress the importance of accurate information enough, because the consequences if your records are lacking, not available, or not accurate are pretty serious. If your records are not accurate or available, and you put forward values, the other side's going to question the credibility of those values.
Yeah.
There will be more scrutiny. There will likely be more requests for more detailed information. There could potentially be a request for a forensic review or investigation. This is all going to be so much more time consuming, so much more costly, and so much more stressful. Like it could literally turn into your worst nightmare.
Yeah, and we talk about this merry-go-round of disclosure, right? When people are not producing it and we got to chase them down. Melanie, you want to add to this?
Yeah, and that's a great point. This is kind of a bane of valuators' existence, is the documentation. And I can only say that over the years, I've seen a downgrading. Businesses saying, well, I want to save money, so I'm not going to get anyone to audit my books. And nobody really the bank doesn't want an audit, doesn't need an audit, so I don't need it. Let's downgrade it to review. Let's downgrade it to compilation. Let's downgrade it to just a Giphy in the tax return. So we'll just have a bookkeeper do it, or my buddy next door. We'll save money. In my experience, and maybe Jason will confirm this, but if you're going to cheap out on that and save money, you're in a situation like a divorce or a shareholder dispute, you're going to pay hundreds and hundreds and hundreds of times what you would have otherwise spent for a good accountant. So get a good accountant. Don't cheap out. It's always important to maintain good records, as Jason said, just for yourself, for if CRA comes knocking, you don't want to be scrambling trying to put things together. And it'll result in more timely and cost-effective resolutions in general.
Mhm.
Messy books are some professionals' dream, because they go, oh yes, this is going to be so much fun. I'm going to spend hours and hours, and I'm going to bill a lot. I'm going to have so much fun looking through all these records. But it's going to be your nightmare. We'll have fun, but it's your nightmare. Not just that you're going to be paying, but you're going to be having to, provide documents, search for documents, figure things out. And you can't always say, worst case, if something goes wrong, I'll just say, okay, I'm going to get somebody to fix the books up. You can't just, if actions have started, for example, if you're not in a collaborative or another alternative dispute resolution, but you're in court, you have time deadlines, and you may not be able to say, okay, I'm going to go get a good accountant, clean books up, give me about 3 months, and I'll come back to you. Maybe not a choice. And a really good example that's been brought up a couple times of why you want to keep good books is if you have marriage date assets, like Russ mentioned, you have to prove that you had it. So if your marriage has been 20 years, 15 years, even 10 years, and you don't have good records, it's going to be very hard to prove that you actually had this bank account or you had this business that was worth X. And that's on you. Like the other side just has to say, well, prove it. And if nobody can find you can't find documents, no one can value it, you're out of luck and you lose the benefit of that marriage date deduction. So I think that was my sort of additional comments there.
A couple of comments I would just add, and I agree with what both of you said. If the financial disclosure isn't accurate and proper, your agreement, if you do get an agreement, can be set aside. You have to start all over again. So it's super important. And like Jason mentioned, this is going to affect your credibility. So if there's a dispute and you've cooked the books or you don't have the records and you go to court, the judge thinks you're misleading the court. He or she may disbelieve you or draw an adverse inference, and things are not going to go well in court. In addition, you may be required to pay costs. Cost is a term that we use saying you may have to pay your spouse's lawyer's fees, or you're going to certainly have to pay your fees if you're hiring a lawyer to defend your case. And that's the financial cost, but there's also, Jason talked about the emotional costs of going through this process. You don't want 2 years of litigation hanging over your head and the uncertainty of a trial simply because you did not keep accurate financial business records. So super, super important. So we've talked about the legislation. We've talked about how these businesses can be a golden goose. We've talked about some process options. We've talked about protecting your business. We've talked about the importance of financial records. Now let's get to the good stuff, right? How are we going to value this business? What are the methods? What process do you two employ so the public can understand? It's not just throwing a dart at the dartboard. There's some science behind this and some methods. So Melanie, can you start us off?
Sure. Sure. And I think to feed on to what Jason said when we were talking about the assets, it depends on the nature of the asset, depends on the nature of the business. So most people are, if you haven't seen a business valuation report, you may have seen a real estate appraisal. And there's generally three different types of approaches. One is based on what the hard assets are worth. And another is based on what the cash flows are worth. And another is based on if there's a comparable business that has been sold. So you might call it asset, income, and market approach. And they're underneath each, there's different methods to get at this. But what we're ultimately trying to do is say, well, what would someone pay for this asset, this business? And the answer, if you put the logical box around it of fair market value, is what a purchaser would get from buying this, right? So if I'm going to give you $1,000 and you're not my kids and you're not a friend, then I'm going to expect something back. So if I'm going to buy your business, in theory, I'm not just going to pay you $100,000 or million or 10 million or 100 million unless I expect to get something back from it. And if I buy it and I operate the business and I get, I'm earning business is earning 100,000 a year, I'm going to pay for that in theory, depending on how risky I think that is. So it's ultimately based on, what type of business is it and what type of asset is it? If it's a company that is more of I'll call it a lifestyle business, where it's, a convenience store, which basically is giving employment income to one or more members of the family. But there's nothing left over at the end of the day. It basically pays for everybody's living expenses. Then in theory, someone's not going to pay that much for it. They might pay for the inventory when they take over and, prepaid assets or whatever it is. If it's a good lease, they might pay something for that. But if I've got an asset that I put money down now, and next year I'm going to get a certain amount of return, the year after I expect to get more return, and on and on and on, then I'll pay something more for that. And of course, if I can find a comparable business, good luck with that. But if I can find a business that's exactly the same as the one I'm valuing, and I can find out something about how it recently sold, then that will help inform for me. So as Russ said, there is some science behind it, because it's really a finance-based thing. You have money, you expect to invest it and make a return. That's the kind of science of it. But it's also not as scientific because we're guessing at what someone would pay, and we're making various assumptions.
Well, it's an informed recommendation, not a random guess, but based on your experience and the data that you have, I think you can come up with a pretty good idea of what the business would be worth.
And I would say I'll just modify that, sorry to interrupt, I'll just modify that depending on how good the information is.
Right.
And great, you'll get a better answer if you have better financial information, for sure.
Garbage in, garbage out. That's the importance of the financial piece, right? And accurate details. Jason, thoughts on valuing methods?
Yeah, I think that was a good summary by Melanie of the different approaches and how you look at, the valuing of business is what it's going to provide for you going forward. The only thing I'll really add is to remember that if you are getting a business valuator or appraiser to come in and value your business, just remember it can be a complicated process. Like, it is a process. It's not just You can't just have a evaluator give you a conclusion like the next day type thing or the next week. Like this is a process we go through for gathering information, for conducting quantitative and qualitative analysis, doing some market research, having a good understanding of the business and all the risk factors, almost like a SWOT analysis. And then, applying appropriate mathematical models combined with professional judgment to ultimately come up with a conclusion and prepare a report.
Yeah, we're getting questions coming in. Keep them coming in. Thank you. We're going to try to get to some questions, but I want to pepper you guys right now and just ask you a few more questions. So, you hear about these businesses that get, 5 times EBITDA or whatever the revenues are, right? Dentist practice in the US, or 4 times or 6 times. I assume that's industry specific, right? The number that you're going to multiply.
I would say, sorry to jump in, I would say it can be industry specific, it can be situational specific, it can be time specific, it can be informational specific, right? And what I mean by that is someone can talk about these numbers, but they may not be based. They may not. I've heard people quote, "Oh, it's 5 times revenue," and you go, 5 times revenue? How could that be? And then you get the information. Oh, it's 5 times after-tax cash flow. Okay, that makes way more sense than 5 times. So you got to be careful when people throw those numbers out, because and evaluators would say they'd have a very disciplined approach to say, where did that come from? Let's try and get some information and make sure that that makes sense. And then is it even relevant to what we're
Some of these, IT startup and software companies, they're getting, millions of dollars and they haven't produced a profit yet, right? The investors are still spending crazy money to pick up these shares. In terms of timing, I assume, and I could be wrong, if I call you up, you're not going to have a number for me the next day. It's going to take some time.
Jason might. I don't know, Jason. Yeah.
So
You're fast, Jason.
What are the goalposts? What should people be expecting in terms of turnaround time if they need to get their business valued?
I think the key is having access to quality information and on a timely basis. Like, I think if we put that assumption out there, that information can be provided in a timely basis, I mean, to go through the process, you might be looking at 3-4 weeks. You might be looking at 6-7 weeks, 1 to 2 months. I can usually turn around a report and go through that process in a month or so.
Yeah. And if you're in court, you have a judge looking at it, you might be 5-6 months just to get a court date, maybe even longer, depending on whereabouts in the province you go to court. So really helpful. All right. So negotiation strategies. Well, one last question. Sometimes we get experts who don't agree, right? That can happen. Not every expert's going to come up with the same result. Would you agree with that, Melanie?
Yeah, definitely.
And
there's ways to deal with that. Some sort of required, some not. But communication between the experts is very helpful. Or that concept of hot tubbing, which is becoming more and more a thing.
Doesn't it sound like fun?
Silly name. Oh,
the judge is telling the experts to the hot tub, right? It's like,
yes.
let's just basically meet and try to get an understanding of what your differences are and provide the court with some guidance in terms of the assumptions you're making, right?
And or if you can make an agreement or something, a compromise, like that's what judges, courts love. Can you guys compromise on anything just for purposes of settlement? And then if the areas you disagree, or can you agree that if there's different legal scenarios, if scenario 1 is the case, what would your numbers be? Would they be the same? And if I did that on one case where we just went through and the lawyers had to argue, but the 2 experts had the same numbers. It was just an issue of the lawyers arguing about what the right result was for the legal issue.
Right. And it might not just be the judge. The lawyers may disagree, they're going to want an answer too, because they need to draft an agreement that hopefully is not going to get set aside. Their professional liability is on the line. If they make a mistake, they could be sued by a client. So oftentimes the lawyers are going to want to get an understanding as to why the numbers are different. So negotiating strategies, tips for achieving fair settlement as well as safeguarding your business. Jason?
Yeah, sure. So what are some tips for achieving fair settlements while protecting your business? Well, I think it goes back to, I think,
Sorry, yeah, that's exactly what we're talking about.
right? That's what we're talking about, right? So
Yeah,
it goes back to being open and honest and forthcoming and transparent. Like if all parties are truly open, honest, forthcoming, and transparent, we're going to have a much better likelihood of having a resolution or a fair settlement. And I think Russ mentioned this earlier when he was talking about the court system versus a collaborative approach. I think using a collaborative approach will go a long ways towards helping to achieve a fair settlement because, well, number one, you're staying out of the court system, but number two, it allows you to sort of focus on your common goals and interests, right? And, they may be preserving the business, preserving your wealth. They may be doing what's best for the children, but if you can have some common goals and interests and you can focus around that, and you can truly work together to generate options. I think Russ mentioned this earlier too. It's like option generation. In a collaborative approach, you don't have to stick to the legal framework. You can throw options out there and you can have a solution that's tailored to your situation.
yeah. Melanie?
Yeah, I completely agree with that. Transparency is great. And I think when there's lack of transparency, that usually equals suspicion by the other party. So if you go down the road of suspicion, whether it's warranted or not, that's going to be a time-consuming, costly, a credibility issue. So transparency is great. And consulting with your counsel about what the issues are, because a lot of people will get their backup saying, well, yeah, I'm not the only shareholder of this company. If I disclose all of this stuff, I'm putting the other shareholders at risk. That's not fair to them. But there is not much room in family law for not disclosing. And, as a shareholder, you are entitled to get certain information documentation. So you can't just say, I'm a minority shareholder, I can't get that. That's not legally true. So you need to consult with your lawyer in that case. But also, as Jason was saying, recognize that disclosure of some information publicly may be harmful to the business. So you may want to go different routes, whether it's collaborative or mediation or arbitration, where things are kept quiet. You may also need non-disclosure agreements, things like that. But there is also, and Russ can speak more to this, a certain litigation privilege where lawyers can't go out and talk to CRA and talk to someone on the street about all the stuff that they just saw from all the tax issues and everything that was raised in this case. So be cognizant of that. Sometimes you're more worried than you need to be. So that's an important discussion point with your lawyers. And I think another thing to really, from more on the softer side, is put yourself in the other party's shoes. You know them better than the lawyers know them, than the evaluators, the other professionals will know them. And be cognizant of their trigger points. Some people are triggered by money, some people are triggered by kids, some people are triggered by things. And it's, if you really want to resolve something without having a big blow up and a very costly undertaking, then play nicely and be cognizant of that. And bargain in good faith, and don't say we're going to mediation and just go in there to walk out and waste everyone's time.
Yeah, I like the collaborative practice approach. My clients often find, I find that they're more satisfied with the outcome as opposed to a judge imposing an outcome on them. Especially, again, we talked about how fragile some of these businesses can be. So that would be my tip. The question asked, a fair settlement, that, what's fair to one person may not be fair to somebody else. So it's kind of subjective. So maybe find a result that's acceptable. Doesn't mean it's fair, but I think people could probably find some wiggle room and negotiate a settlement if they think it's acceptable. Full disclosure is number one tip right after getting professional help from either an expert like we have here tonight, Melanie or Russell, or Jason, sorry, have
Melanie Russell, yeah.
have a lawyer help you through the process from start to finish. Don't wait until the deal is done to go get advice. You're going to want to make sure that the deal is proper and thorough. Be prepared to make some compromises. Last thing, like, you don't want to spend, your child's education fund going to litigation to have a judge come up with a decision you may or may not like. So if you can do some compromising along the way to come up with a settlement, that's always a good tip. So really, really great discussion. Lots to unpack there. Let's move into legal protections, options for implementing legal safeguards to shield your business from divorce-related risks. We talked about a lot of these tonight, right? Domestic contracts at the front end. Consider whether it's excluded property. Consider getting releases to certain aspects of your agreement. Spousal support release, right? Your settlement agreement should have a full and final release, but you're going to want to make sure that you protect the business from future claims. So if the business grows and becomes significantly more valuable, you don't want your spouse to come back and take another kick at the can, unless something that you specifically agreed to. And so you want to take a look at that. The type of business entity that you're using, whether you want to incorporate sole proprietor, take a look at whether you family trust can somehow shield some of these assets. Look at the shareholders agreement and partnership agreements. Look at key provisions in those agreements, buyout clauses, valuation clauses, restrictions on the transfer of your interest. Look at the employment agreements that your business enters into. And you could probably build some protection in terms of the employment agreements that not only for your own pay, but if there's adult children working in the business, you want to take a look at that. Certainly going to want to explore insurance. So life insurance, disability insurance, what kind of insurance should you put in place to help safeguard this asset? And consult with professionals like the people you see on your screen tonight and follow their advice. They're very good at what they do, and it's going to save you money in the long run. How about tips for legal safeguards or protecting your business? You want to add to that, Jason?
No.
Or Melanie, you want to add anything before we move on?
I think you covered it all. Sounds good.
Okay. So, final topic. Co-ownership considerations, addressing challenges and solutions when business partners are involved in divorce proceedings. We sometimes call this the Greek chorus, right? The not so silent business partner. But why don't you start us off, Jason?
Let Melanie go on this.
Okay.
Sure. No problem. So, and Jason had talked about this, and also Russ has talked about this as well. When you've got co-ownership, you have more than just a family law issue. You have a commercial issue in theory, right? And ideally, these things get addressed beforehand. So often there's tax planning, as Russ was talking about. Smart tax accountants and lawyers talk about, co-ownership, sharing the small business, the lifetime capital gains deduction, setting up trusts, etc., which sound great, and they can be. But usually when they're planning, the expectation is everyone's staying together. Like they don't necessarily think, "Ooh, what happens if?" And the problem is a lot of times that if happens, it's not so much if anymore. So it sounds silly, but getting shareholders agreements in place, even in a family-owned business, whether or not the spouse is active in the business or is inactive in the business, just deal with it. Get it done. Sounds silly, but very important. Because the problem is when you get to a separation, and let's take the simple situation of the two spouses who are separating own 50% of a business or businesses or whatever it is. In some ways, who cares about equalization? Because whatever, if I'm one of those spouses, my value is the same as his or her value. So who cares? Why are you going to get the valuators to spend all this time valuing it at separation date? What you really care about is what happens after. So am I going to be bought out? Am I going to stay in? How much am I going to be bought out? When am I going to be bought? Do I do it at the separation date and pay you 50% of that? Do I say, well, no, 3 years have gone by, I still am a shareholder, so you have to pay me today's value. So it creates a whole bunch of other issues, and it that could be often could be simplified if you had a shareholders agreement that doesn't out, because unfortunately there is no, without a shareholders agreement, there's no forcing either one party to buy out the other party or the other party to sell. So you may get into that situation that equalization, no money's changing hand, but the parties, maybe one party is not involved in the business and needs money to buy a house. And if this is the major asset, they're stuck with the shares. And the other party saying, yeah, you can stay in. Or the other party saying, I don't want my ex-spouse seeing the records, having access to, having to come to shareholder. I now have to actually do shareholders meeting, invite that spouse, and they get to hear all what's going on in the business. But that spouse doesn't have to sell if that spouse doesn't want to. So you can get into very ugly situations. And Jason's probably done a lot of these, as I've done a lot, where you have a family law proceeding at the same time you have the commercial proceeding, and one party's claiming oppression, whatever else, to try to get a resolution on the shares. So commercial, really important. And I think one of the other important things, I saw this many, many years ago, which was really impressive. I was kind of impressed by it. I think one of the first questions is, can these ex-spouses still work together? If you've got a situation where there's two working partners, can they work together? Sometimes they can. Sometimes they don't want to be together anymore as a couple, but they want to keep running the business. Other times there's just no way it's going to happen. So that's one of the first questions on one of those situations. And then you can create a solution around that.
Yeah, Jason?
Yeah, I think those are great points. And both of you brought up the issue of having a shareholder agreement. I think that can't be overemphasized. Whether it's a situation where both spouses are joint owners in the business, or whether it's a situation where you have an owner that is not part of the divorce proceeding, but is just another owner. Like, a shareholder agreement is so important and is going to be so helpful, and possibly even consider going further and having buyout clauses and regular valuations built in sort of to the annual or biannual process. Because if you think about it, if you're going through a divorce, a separation, you need to value the business. If you have a business owner that has a vested interest in the business because they have shares, but they're not part of the divorce, well, they're concerned about the future of the business. What's the divorce going to do to the business? What confidential information are we going to be disclosing as part of this divorce? So I think in that situation, like, you need to have discussions up front and make sure you set some ground rules, like maybe the business partner is able to assist with providing information because they're knowledgeable about the business, but they're not going to be attending any settlement meetings or be involved in the divorce proceedings in any way. I know Ross has had situations where those business partners want to come to the table as well, but it's an issue you have to deal with sometimes.
Yeah, that's the Greek chorus, right? Where, and with all due respect to the business partner, this is their livelihood too. This is their asset. I completely understand why they want to be involved in any decision making that's going to affect their interests. But as Jason indicated, we had a business partner who wanted to attend the settlement meetings for the divorce proceeding. And we said no. But we did permit that person to meet with our expert who's doing the valuation and get an understanding of the numbers that we're working with. And the other thing that does, if you think about this presents you with options, right? there may not be another buyer for this business, but if the partner wants to increase his interest or her interest, that can form a settlement option that wasn't on the table before. So you want to be thinking about these things all the time. One of the somebody may ask, why would people not want to continue with the business? There's lots of reasons why not. There could be infidelity, there could be infidelity within the business that caused the relationship to fail. Could be a domestic assault situation, or there could be criminal court restrictions preventing somebody from having contact with their spouse. Lack of trust is another theme that we often see for people going through divorce. And there's just not enough goodwill or trust to hold on to this asset and ensure, with the hopes that the other spouse isn't going to run it into the ground. But the flip side of that is some people are very successful at continuing to operate the business together. They just decide to live their lives separately, and for whatever reason. So we see everything. Those are the main topics. I just want to hit a couple questions here, and then we're going to sign off. I want to thank everybody on YouTube who are live streaming us, and also our audience tonight. Question came in a little while ago. If one spouse is not operating above the board when it comes to business-related behaviors, i.e. cash transactions, side gigs, the other spouse is aware but can't get them to stop, how does the court view this? Well, we've had cases like this. How do you guys deal with these issues? And then I'll talk a little bit about my experience with the court. So we got somebody, cash on the side gigs, spouse knows what's going on, but what do we do with a situation like that?
So, okay, I'll just mention something, then Jason can pipe in. I think in my experience, I've seen the gamut of someone thinking there is side gigs and they're not being, and someone thinking there is and there is. So, and that can be very challenging, and it can be, how do you prove, how do you investigate it to get this person satisfied? And there may be no way, or I've had clients who said, if let's do this, I just want to know, because I will not be able to close the book on this unless I know this. So we develop some procedures and say, here's what we're going to do, and whatever the results are, the results are. I think in general, and Russ can probably speak to the court side of it, but in general, the lack of transparency and not telling the truth is through financial information, through saying I want to reduce taxes, is not very uncommon, and because the motivation is often to reduce the taxes. So it can be problematic, but finding it and proving it can be almost as problematic, as depending how good the person who's committing that and how closed mouth they've been. If they've said, hun, I got $10,000 in cash today, and throw it on the bed. That's going to be a little easier than someone who doesn't talk about it, and the spouse does not know anything about what goes on in the business.
Jason?
Yeah, this could be the most difficult issue that we deal with. And the allegations come up a lot, and we have to look into this a lot, and we have to make assumptions, because if you truly are doing cash deals on the side and you're taking that cash and spending it on things, how can you trace it? How can you track it down? It's so challenging. I mean, there are things you can do to sort of, provide some indicators. If cash is going into the bank, you can look at bank statements. And maybe you look at the spending, maybe you look at the other side of things, and like just the income that's being reported is not supporting the lifestyle that we live. So you can look at an assessment of the spending through the credit cards and bank statements and anything else, just to try and reconcile the spending to the income that's reported. And if there's a shortfall, I mean, aside from taking loans or changes in savings and loans, like maybe it's being funded with unreported cash. It's difficult though.
Yeah. Oftentimes, it's like Melanie said, what people report to CRA is not necessarily what their income is. And courts are well aware of this. And Lifestyle analysis is a great way to do it. If you're telling CRA you make 25,000, but your financial statement shows you're spending 110,000, you've got a pretty good argument to tell the judge, I want income imputed to this person so they can pay the proper level of support. But to give you a real life example, I had a client charged criminally with domestic assault. Charge turned out to be false, but it took 2 years to get to that point. So there's no trust at all between her and her spouse, and was concerned about cash deals, side deals, this and that. She sat with the business evaluator, went through it line by line. They agreed, yes, these items are improperly being expensed to the business. That's going to be added back to that person's income and grossed up to reflect what the cash value was, and as opposed to taxable income. That's a great way to do it. So look at the financial statements, see if there's an explanation. If they're spending more than they're earning, there isn't an explanation, you got a good argument to say the income should be imputed. Use experts like Melanie or Jason tonight. They do income assessments and they will report back to you what their findings are. This is expert evidence that a judge can rely upon and often do in terms of coming up with support calculations. So if you have an expert report and an expert testifying, here's my findings with respect to John Doe's income or whoever it is, then the judge can then look at the child support guidelines, the spousal support advisory guidelines, and craft a support order based on what that person really is making. So it's difficult. It could be time consuming. It can be inexpensive, but there's ways to go about solving it. So great answers. One final question, and then we're going to wrap this up, and I'll throw this out to both of you. We've talked about the importance of financial disclosure. If somebody owns a business and requires your assistance, what are some common documents you're going to want to see, or you're going to want them to start to assemble so you can make an informed decision? Jason, you want to go first? What are some of the things you're going to want to see from the business owner?
Yeah, if we're doing a valuation of the business, then we're typically going to ask for financial statements of the business for the 5 years before the valuation date. We're going to want to see the most recently filed tax returns of the business. We're going to want to see business plans, forecast projections if they are prepared. We're going to want to know information about the business, about the customers, about the employees, about the location, about the size, all of that stuff. We're going to want to know about the owner compensation and any compensation to related parties or family members. We're going to want to know about personal expenses that are paid by the business but not required for the business. So it's a lot of that type of information.
Melanie?
Yeah, that's a great list. And again, it depends on the business too, because there'll be some things tailored to a particular business or industry. But past valuations, past key and reports that have been done, shared transactions, key agreements, organization structure, whether they're who are the related parties, so that you can understand where money may be going or may not be going and why. And I guess also I'd say one of the things I always ask about is if there's any intangible assets that aren't sitting on the books that we may need to know about.
All right. On that note, we're going to bring this train into the station. Jason, thank you for joining us tonight. Melanie, thank you. Thank our audience for showing up. I did put a code into the chat. Summer 2024 is the code. You want to contact Nicole at russellalexander.com. She can arrange a 20-minute consultation if you want to get some tailored legal advice to help you understand how to value your business or what steps you should be taking. That code is valid until this Friday, and then it expires. Doesn't mean you have to have your appointment by Friday. You just need to call to set your appointment. I want to thank everybody on YouTube watching. Thank our audience for watching. This has been a great series. If you have some questions or suggestions, there'll be a survey that pops up. You can even give us suggested topics you want us to cover. But this has been a great discussion tonight. So thank you so much, Melanie, Jason.
Thanks.
And
thank you.
Have a great evening, everybody. See you later.
Good night, everyone.